Well, the U.S. Supreme Court recently concluded its term, and there have been a lot of high-profile rulings that have sparked some debate online. So what is the correct take on many of these contentious issues?
So if that's all you had to go on, the text of the Civil Rights Act, the text of the 14th Amendment, then I think the majority's ruling is pretty solid. The context may complicate that some in terms of legislative intent.
On this episode, I sit down with two constitutional experts to parse through a grab bag of recent U.S. Supreme Court rulings so you can know which online takes are good, bad, and just plain constitutionally ignorant. This is Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome back to another episode of Defending Ideas. I'm your host, Nick Dunn, and this week we're talking about the U.S. Supreme Court just finished its term, so you've probably been seeing a lot of news coverage over the last couple of weeks of the different cases that were decided. We're going to dive into some of those and talk about some good takes, some bad takes, and just a better way to think about Supreme Court rulings on issues like this. Very excited to welcome into our virtual studio Matthew Brogdon. He serves as the Senior Director at the Center for Constitutional Studies at Utah Valley University. Matthew, thanks for joining us.
Thank you for having me.
And in our physical studio, Bill Duncan, our Constitutional Law and Religious Freedom Fellow. Bill, welcome back.
Thanks. Nice to have you. Or nice to be with you, sorry.
I'm really excited to talk to both of you guys about this because Supreme Court cases are always interesting and contentious, and there's a lot of debate in the public, in the news, on social media. And I really just kind of want to dive into some of the most noteworthy cases that the court ruled on from this recent term and give our listeners the benefit of your perspective and help increase our civic understanding about these issues. So maybe to start, one of the big cases from the term is the debate over birthright citizenship, the Trump v. Barbara case. And I'll just kind of ask both, maybe Matt, starting with you, what do you think? Tell us about how the court ruled, what the arguments were, and kind of what your take is.
Well, the majority of the court ruled that the executive order was unlawful. There was a little bit of difference of opinion of why that was the case. The executive order itself had held that birthright citizenship should only be enjoyed under the 14th Amendment by people who were permanently residing in the United States. So this would exclude expressly folks who were visiting temporarily or people who were illegally present in the United States. The court said that was unlawful. 5 members of the court thought it was unlawful because the 14th Amendment itself does not allow that kind of constriction of birthright citizenship. Justice Kavanaugh made a 6th vote in the case, but he thought while Congress has legislated this broad definition of birthright citizenship, the Constitution leaves open the possibility that Congress could further constrain it, exclude other individuals who don't merit birthright citizenship under the text of the 14th Amendment. But in his estimation, an executive order is not adequate to change that congressional understanding in the law. The other 3 members of the court thought that the executive order should at least be left in place for now until we find an occasion where the 14th Amendment's clearly being violated. They were not in favor of throwing the whole thing out, though they variously thought there could be circumstances where the executive order might violate the Constitution or federal law. They just didn't want to throw it out all at once. So that's sort of the situation that the court finds itself in with the case.
Bill, what's your take? As I read this, sort of based on Matthew's description, and this is my understanding how the Supreme Court works in general, is in this instance, you could either say, well, the executive order sort of limiting birthright citizenship in this way to exclude illegal immigrants, the executive order was illegal, but that action wouldn't be unconstitutional if Congress were to do it. So that's almost kind of a separation of powers argument, or the deeper argument of, no, Congress couldn't even do it. It would violate the Constitution. What's the correct view, or what do you think about those different viewpoints?
Well, let me say maybe as a service to people that are interested in this. I think Dr. Brogdon wrote a great piece in Deseret News that is really helpful on this, and will give a better take on the case. You mentioned there are bad takes and good takes. A good take is what he wrote about this case, so that would be a helpful way to learn a little more about it. It's one of those cases. It's not initially easy because the language of the 14th Amendment is. It starts really simple, that anyone born in the United States or in any of the states is a citizen of the United States and of the state. But it has an additional clause, and that's, of course, where all of the argument is around. Because it says that person would also need to be subject to the jurisdiction of the United States. And so the question is if someone is come to the United States and with the intention of having a child, to maybe get kind of ahead in terms of potential immigration status, or just kind of on the off chance. I think there's a somewhat famous story about someone who was born as their parents were I think it was between flights, and the parents weren't United States citizens, but the child becomes a United States citizen under the Birthright Citizenship principle. And so, in those kind of situations, is a person subject to the jurisdiction thereof? Well, the court had to grapple with questions about, well, what did Congress and those who ratified the 14th Amendment in 1868 think that they were doing? I mean, did they intend to include people who were in the country temporarily? And I think I read a lot on this question, and it wasn't easy. I think that the majority was right in their decision. I think that the original meaning of that part of the 14th Amendment doesn't have a lot of exclusions, and that subject to the jurisdiction thereof is a pretty narrow exclusion. But having said that, it's not a given that you can't. You could read this in different ways, and I think all of the justices were more thoughtful than the coverage may give us a sense of.
I agree with that. I do think there's an alternative narrative about the meaning of subject to the jurisdiction thereof that Justice Kavanaugh, as well as the three dissenters, all provide, arguing that to be subject to the jurisdiction thereof means to be completely subject to it, not just partially. And they put a lot of emphasis on the term domicile and marshal some examples of Congress and of courts in the late 19th century, in the relevant period, denying citizenship to people who weren't domiciled in the United States when they were born. In other words, people who intend to make the country their home. Now, that's not apparent on the face of the 14th Amendment. And if all you had was the text of the amendment to go on, one might think that the construction's uncontroversial. Anybody who's partially subject to the jurisdiction of the United States is subject to it. But the context, they marshal a lot of evidence to suggest that there might have been a different and more narrow conception of what that meant. Incidentally, the Civil Rights Act that preceded the 14th Amendment had similar language, but it was a little different. It said all persons born or naturalized in the United States and subject to no foreign power are citizens of the United States and the state wherein they reside. That language certainly lends it to this idea that if you keep your citizenship somewhere else and just visit here, you're subject to a foreign power, you wouldn't be eligible. The 14th Amendment changed that language to subject to the jurisdiction thereof. So if that's all you had to go on, the text of the Civil Rights Act, the text of the 14th Amendment, then I think the majority's ruling is pretty solid. The context may complicate that some in terms of legislative intent.
And just for clarification for our audience, this doesn't really change anything, right? Basically, the birthright citizenship has been the status quo for quite a while. The Trump administration executive order was trying to change that. So the Supreme Court ruling basically says, no, we're going to keep doing what we've been doing for birthright citizenship. Is that accurate?
Bill, I think so. Do you have any?
That's right. Yeah, I think that's right. And the question will be whether with Justice Kavanaugh's opinion, there may be a feeling of, could we change that statutorily? As a matter of separation of powers, I think it's good that if there is room for a change under the 14th Amendment, that the change be made by Congress, not an executive order.
Yeah, the executive order was very broadly drawn in terms of the exclusion, and I do wonder if Congress were to craft a narrowly tailored exception to birthright citizenship that they think fits within the subject to the jurisdiction thereof language. For example, to ban birth tourism, for example, or deprive of people who intentionally come here just to gain citizenship with no intention of residing. I do wonder if you might draw over a justice. You would have to persuade Justice Barrett or Chief Justice Roberts to move over and approve that as applied situation, or that narrowly tailored remedy. There's not much room for that in the majority opinion, but justices have changed their mind before, and we'd be moving from a challenge that just challenges it on its face and asks the question as a general matter to one that's about a very specific policy, which might produce a different outcome.
So I think to wrap up that topic, to me, one of the key themes that stands out is, at the very least, there is a kind of federalism and civic knowledge point to make, that for those folks out there who do think, well, we need to curtail birthright citizenship, whether you agree with that or not, the proper avenue is not going to be an executive order. Maybe an act of Congress, given what you guys are saying. And I know I've seen other folks online saying, well, those who want this, they would have to pursue a constitutional amendment. But at the very least, hopefully this can sort of show people that trying to make sweeping policy change through executive order is not really a good approach.
That would be good, I think, takeaway. just as a general matter, I think that's a good takeaway. I hate to kind of add some levity into this because I know the issue is quite serious, but some of the takes have been really quite funny and maybe in a distressing way. I think I mentioned to you before the call that I had the headline. I don't read these kinds of things when I see a email with this subject line, but it was something like, Trump needs to fire Justice X, who is in the majority, kind of, and it's helpful. We can have a very constructive discussion and I think understand much better if we're willing to kind of pay the not that high a price to try and understand what is the court addressing in these questions. And again, Dr. Brogdon's point teed that up perfectly. We're asking a broad question about a broad policy, and so we might get different answers under different circumstances. And some of the other cases we'll talk about, I think, will raise similar kinds of concerns. But yeah, as with everything, it's good to take a deep breath and what actually happened here.
And if nothing else, try to elevate some constitutional literacy of folks out there. One of our goals here on this show, of course. I want to talk about a couple of other cases. There are two cases that really kind of deal with this idea of the president's power to remove people. And as I kind of saw the coverage, it's sort of this basic question: does the president really oversee or manage the executive branch? And if so, kind of to what extent, or what are those powers? And so there are two cases I want to ask you guys about: Trump v. Slaughter and Trump v. Cook. Trump v. Slaughter is the president's power to remove an FTC employee, and Trump v. Cook, presidential power to remove, kind of focused on the Federal Reserve side of things. So maybe, Matthew, go to you first. Talk us through that debate of, does the president really manage those people or not?
The Constitution says that the executive power shall be vested in the president, and there's a period at the end of that sentence. The whole executive power, whatever it is vested by the Constitution and the president. So the question is, when other people are aiding the president or exercising executive power, how much control does the president exercise over them? And at least with respect to cabinet officers, the people at the heads of executive departments, Department of Defense and State and Treasury and all those folks, very early on, Congress decided in the first Congress in 1789 that those folks should be removable by the president. And subsequently, most people read that debate as having settled the question, that those principal officers in the executive branch that exercise executive power have to be removable by the president. And that's not just because of the text of the Constitution, but because the president's responsible for their actions. Whatever the executive branch does, the president faces the political consequences. And so if you want the execution of the law to be responsible to the people, that needs to operate through the presidency. So that general framework governs. Now, throughout our history at various times, Congress has found reasons to shield certain officers who might be appointed by the president from subsequent presidential removal, either attaching a for-cause provision to it, saying this person can only be removed if they do certain things, or often attaching a term of office, saying this office serves for this term of years, the implication being you have to wait until the term's exhausted before you can replace them. And that has always raised this constitutional dispute. On what ground can Congress shield those people from the president's control if he has the whole executive power? And the answers to that have really been twofold. Either it's because the people that we're talking about are not really exercising executive power. They're doing something that's more legislative or judicial. And just like the president appoints judges but can't remove them, in the same way, you wouldn't expect the president to be able to remove another judicial officer. So that's one justification. Another is that maybe requiring the president to show cause to remove somebody is not a material interference with the president's control of the executive branch. As long as he can ensure that the people who are exercising this power are not misbehaving, that they're handling their offices competently, that's fine. To say that that they have to agree with the president in all things is too much control, and the Constitution doesn't require that much. The court in this case, in Trump versus Slaughter, said that logic of presidential responsibility and control extends to what we call administrative agencies, in this case, the Federal Trade Commission. This would also apply to things like the Securities and Exchange Commission, the National Labor Relations Board, all these administrative agencies that Congress has traditionally shielded through for-cause removal. Those for-cause limitations on the president's removal power are gone now. The remaining question is, what do we do with the Federal Reserve? Is it the same? And I'll hand that one to Bill.
And the answer is no, it's not exactly the same. But and I think, as I understand it, you may have a different take on this or better take on this, I'm sure. But my sense is that Congress, the creation of the Federal Reserve is different in the way Congress has created it. With, I think, terms. I think terms was an important part of that decision. And so there are some limitations maybe in that very specific circumstance on what the president can do, even though the same basic principles apply. There's a lot of interesting things to say about this question, and it's another one that's been misunderstood because there's this an underlying question about, well, how much power is it okay for one person to have, and all of those kinds of things. But again, when you look at the actual legal issues, I don't think they're as challenging. I think they think they can get to some consensus. Maybe just as an example, one of the cases that I'm sure everybody was, or one of the issues in these cases that people were wondering about is an old case from the 1930s, if I remember right, called Humphrey's Executor, which sounds exciting just saying it, but that was where the Supreme Court had sort of blessed the idea that Congress could create requirements on removal and limited, in this case, President Roosevelt's ability to remove an executive branch official. And the story, as I understand it, is that the president was furious at the time. How can I set policy if I, in terms of enforcement, and he had a very expansive policy of the things he wanted to do executively, was angry that happened, but that limitation on presidential authority is now gone. That raises a couple of interesting questions. For some people, that's troubling because they say, well, look, if this has been the policy for a long time, it shouldn't change. I mean, that sort of unsettles things. But on the other hand, there's an important question about if the court in the past has done something clearly that now seems to be clearly either not required or foreclosed by the Constitution, in this case foreclosed. Shouldn't the court correct that in appropriate ways as soon as they can? And that also is a subtext for this discussion. It's important too.
Matthew, I want to give you some final words because I know we're on a limited time frame with you, and we're grateful for your analysis. But anything else on these cases about presidential removal authority or any of the other cases with the term that you want to make sure to weigh in on for our audience before you have to go?
Well, I think the Federal Reserve question is really going to stick with us. I mean, the court did not really finally decide this question. The majority says, in the majority opinion, that they're deciding the constitutional question, but really it was just a question about whether to let the case go back to trial. And what the court technically decided was that Lisa Cook has a right to challenge through some sort of procedural mechanism her removal, and that the president's going to have to justify that. I don't think that's going to be the end of this case. We're going to see it again. And there's a serious historical dispute. I think there's a through line in many of the cases this term, the removal power case, the birthright citizenship case. I think you can also see that, in some of the others as well, the tariff case, a real dispute about the history involving these situations. And the Federal Reserve's no different. There's a real disagreement between the majority, which thinks the Federal Reserve System or Federal Reserve Board is just like the first and second banks of the United States, which were with us in the early republic and therefore carry a lot of weight. Whereas the dissenters in the case, and it's well worth reading Justice Barrett's dissent, I think, in that case, because, she argues, look, it's not that there are no problems constitutionally with shielding the Federal Reserve, but you can't just equate them with the first and second banks. They are different. They exercise a regulatory power that the first and second banks never did. And there's been some fascinating scholarship on this in the law reviews that I think is going to play a much bigger role as this gets litigated in the future. So I'm not sure this is the end of the Federal Reserve Board question. I think we may still see some more challenges and some adjustments to just the way that the presidential removal power works. It wouldn't even surprise me to see the court say that certain things that the Federal Reserve Board does are unconstitutional if they're shielded from presidential control, and sever some of those and leave it in possession of the purse strings. Because at heart, the question is, like that framework I laid out at the beginning, is the Federal Reserve Board doing something other than the executive power? And the argument for that is that they're helping Congress manage the purse strings, the money supply. And that's not just an executive power, that's actually a congressional or legislative function under the Constitution. And if that's the case, then perhaps it is appropriate. So the court may have to really revisit at some point in the future, to what extent is the Federal Reserve doing some other executive functions that not just about managing money, but about regulating banking that they may have to pull apart. So I would expect to see more on that as this develops in the future.
Matthew, we're so grateful for your time. Now you've got classes to teach and a lot of great things going on down there at the Center for Constitutional Studies at Utah Valley University. But we're grateful for your time and expertise here on Defending Ideas.
Thank you, Nick. It's a pleasure to talk to you and Bill.
Bill, I wanted to follow up on a couple other court cases, and grateful to Matthew Brogdon's time and his analysis. But there were a lot of cases that really, and maybe this is sort of dumb to say, but got to the heart of separation of powers and the role of our constitutional structure, which is really kind of what the court is supposed to do. So in some ways, that's a good thing. But I want to ask about, there was another case, Watson v. Republican National Committee, dealing with absentee ballots. Can you give our listeners a quick overview of what that case was and how it landed?
Yeah, this is not one I've watched as closely, and so I wish Dr. Brogdon was here. He seems to know everything and such a great resource. But yeah, basically, so the concern in that case, so some states, many states, will count ballots that are received after election. So in other words, you got it in the mail, but it wasn't delivered on election day. Can those still be counted? And the Trump administration position and position of others is that no, the election day is a day. It has to be, if the ballots are not received that day, then end of story. I mean, it's kind of simple. That's sort of the constitutional argument. The majority of the court said no. States have some leeway to determine how to, the vote was made in time, and so states have some authority to count those. We don't need to micromanage that. If Congress, of course, remains free to say that that's the case, that because the Constitution gives the states the initial ability to regulate elections, but allows Congress to override what the states do in some kind of probably rare circumstances where there might be a need to do that. One of the reasons that I think this has been such an interesting topic is that there are so many other challenges to kind of election integrity. We've had a previous episode to talk about this that I thought was quite interesting. And so in a way, late counted ballots are probably not the most exciting thing, but there are other questions like, I mean, here in Utah, does the lieutenant governor have to provide information to the federal government about Utah's voter rolls? That kind of thing raises all kinds of concerns about privacy, about the national authority versus state authority. These are significant questions, and I think it's positive that the Supreme Court is again trying to be very thoughtful about this, trying to understand kind of the exact nature of the separation of powers questions, including the both separation of powers in terms of the agencies of the national government, also federalism, the ability of state. What role do the states have? Can the president impose a national standard on the states? And so I think that this decision will be a positive one going forward in terms of at least giving a sense of what needs to happen next if we need to make changes to election regulation.
Bill, let me try and steel man the other side a little bit, or sort of play devil's advocate, because I think this, maybe with a lot of these cases, so this is probably a standard theme for our folks watching or listening out there, that they might hear the way cases decided and say, well, that just doesn't make sense to me, sort of as a matter of common sense, or what I would think would be the right policy approach. So I want to try and channel some of that with this one, that wouldn't it be reasonable for someone to think, well, hang on, election day is election day. We've heard the stories of California, places in California taking a long time to count ballots and they come in. So if you're stretching out sort of the election, days or weeks or maybe even longer, in terms of it just takes forever to know who won the election, and it gets really muddy. Couldn't that sort of cast doubt on election integrity, election security? So what is the sort of constitutional lens or legal lens to respond to that, saying, well, wait a minute, it just doesn't make sense to have ballots trickling in for days or weeks?
Right. Part of the answer is who gets to decide those questions, and this is sometimes challenging because, of course, the issues that the court deals with are big issues. Who is a citizen of the United States? Who gets to vote when? When do we count votes? And can people who've used marijuana own weapons? I mean, there's a whole range of pretty fascinating, potentially significant issues. But the Supreme Court is not weighing in on questions like, what would be the right time to count ballots, or when should we get that information? They have to address more discrete legal questions. So the question the court has to address here is, what did Congress intend when they created the current statute? What did they say? What did their language? I said intend, but I should pull back on that. What did they say when they did that? What did the words mean? What was the understanding?
The words of the law.
The words of the law. And that's a different question than what should the law be. So we sometimes channel our frustration with the second question, what should the law be? Yeah, we shouldn't have to wait so long. States could do a better job. They ought to be counting this. Election day is election day. All of which I think are very reasonable policy positions to have. But they're a little bit different from the legal questions that the court has to answer. And the court wants to, I think, on purpose and by virtue of their role, to stay away from question 2, what's the right policy, and only deal with question 1, which is what has Congress done to this point. And if they do that, we're actually in a much better position. Now, that will be frustrating if we think, well, Congress is not doing the right thing, so the court needs to step in and fix things. But we don't want the court stepping in and fixing things in every circumstance. We only want them to do that when the answers are really quite clear. And when they do, then their authority really can be a great help to our system to preserve constitutional and legal principles when they stay away from those kinds of policy issues that Congress really ought to be addressing.
Well, in the minute or two we have left, I want to kind of go down the list to some of the other high-profile cases on tariffs. Learning Resources v. Trump on tariffs. Anything you want to weigh in on there?
Well, similar question. I mean, the question is not whether tariffs are a good idea or not. There's definitely a lot of historically that's been a really important issue in the United States. But the specific question in that case was, can the president do that without any specific authorization from Congress? And the Trump administration in this particular case had stretched the congressional authorization probably beyond what the language would support. And so this is one of those kinds of issues where if you think tariffs are a great way to raise revenue and other kinds of things, then Congress should be the source of fixing that legal problem.
And then as we go down the list as well, any of the other cases we've missed that you want to make sure you get a chance to touch on?
Maybe I could just say something about one case, and this is because this is the area that I write in probably the most, and that's religious freedom. There was a case that might have surprised some people because the majority of the court, a 6-3 majority, ruled against a prisoner who very clearly had his religious rights infringed. It was really an egregious case where against court orders and all kinds of other things, a prison official had shaved a Rastafarian prisoner whose belief included that he can't have his hair cut. And so nobody's defending that. It's wrong all the way through. So people were surprised when the Supreme Court ruled that the prisoner's lawsuit against one of the individuals, one of the officials, could not go forward. And this is again one of those issues where understanding the legal question really, really becomes important, because the U.S. Supreme Court has been a very steadfast defender of religious freedom and not just religious freedom of Christians, because that was a criticism. Well, maybe they don't understand how important these issues are but they've been strong in defense of the rights of Native American religious for Jews and others. So I think it's an unfair criticism of the court. The specific question was a statute passed by Congress. It gives prisoners and others the right to bring a lawsuit, specifies which lawsuits can be brought. And the dissenters believe that we could imply that includes a right to sue an individual government official. But it wasn't clearly in the statute. Now, I have to say, I actually had argued before that I think they should have implied that right, and so I'm not. I didn't necessarily see things exactly the way court did, but I think it's important to recognize that reasonable positions you can have reasonable positions on this, and thoughtful judges can come up with a solution as long as they are constrained by the understanding of the statute as typically clear in the text, and resist. I think they're right to resist implying things that are in statutes that are not clearly there. So I think given all of those factors, the court may have done the right thing, and Congress is free to make clear that if they did intend that, if that was in their minds, but it didn't get into the statute, they can change the statute and fix that problem. The court doesn't have to be the only source of understanding of the law, because the other branches have important roles to play, and when they do that, then the system just works better, and our constitutional rights are more secure.
Well, Bill, last question before we sign off for this discussion. I want to ask you to grade the court on a scale of 1 to 10. If you look at all of the rulings from this term, 1 being terrible, not aligned with the Constitution, totally devoid of any constitutional literacy or abiding by the law, 10 being everything was perfect. They were the most constitutionally, legally bound court you ever could have had. Where would you put this term?
I'm bullish on the court. I think the court does a great job. I think that I would put it as an 8. There are some things individual decisions and some rationales I don't agree with. There was a case about taking after someone's property is seized. I think the court got that one wrong. But having said that, the level of thoughtfulness of the opinions, the approach of the court to try to always apply the original meaning of constitutional and statutory text, I think that's exactly what it should be doing. Will there be mistakes made or perhaps the wrong position prevail? Absolutely. I mean, there are many cases where I think I'm with the dissenters on that one. But the quality of the court's effort, the very like Dr. Brogdon said earlier on this episode, their effort to kind of look at the history and be serious about that's a really positive development. And I think reasonable minds will differ. That's okay, as long as they're looking for the right things. And I think the majority of the court is doing that. So I would give them a solid A-.
Well, we will leave it there. Bill, thank you. We're obviously going to continue these conversations, but appreciate your time and expertise.
Thank you. Thanks for having me.
We're going to take one final break before we leave you all with some talking points from this episode. This is Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org.
Welcome back, and thanks again to Matthew Brogdon of the Center for Constitutional Studies at Utah Valley University, and of course, Sutherland's Bill Duncan. There are really two key principles that stand out to me from today's discussion. First, when you're hearing news coverage or public debate about U.S. Supreme Court rulings, the question you should strive to answer is not whether a ruling is reasonable to you on policy grounds. That's not actually the court's job. Instead, ask yourself these questions on each of these topics. Whose responsibility is it to actually answer the policy question at hand? And what does the text of the law or the Constitution actually say regarding the issue? That is, in somewhat simplified terms, what the court is supposed to do. Second, and related to the first, the job of the U.S. Supreme Court is not to fix policy mistakes that Congress makes either explicitly or by omission. If you want better policy decisions, that's what Congress is for, or better yet, your state legislature. Looking to the court as kind of the last vestige for your preferred policy outcomes, almost like an untouchable super legislature, is simply not what the Constitution envisions. Well, that's it for this episode of Defending Ideas. If you enjoyed this discussion, please visit defendingideas.org, where you can access previous episodes and watch or listen on your favorite platform. Don't forget to subscribe to Defending Ideas on Apple Podcasts, Spotify, YouTube, wherever you like to get your shows. And please share this episode with a friend, family member, or coworker who may find it valuable. And lastly, if you want to support the broader work of Sutherland Institute, or if you just want more conversations like this, please make a contribution at sutherlandinstitute.org/donate. Thanks again for joining us on Defending Ideas from the Sutherland Institute in Salt Lake City. I'm Nick Dunn. We'll see you next time.